Good morning to all of you. Welcome to Legal Matters by Sai Babu Sankara. In this video, we are going to discuss a judgment given on the Section 69A of the Income Tax by the Honorable Supreme Court of India. The heading is catchy. Thief cannot be assessed as owner of the property. So, even though the property is found with the thief, he cannot become the owner. You cannot levy tax on him. This is the crux of the judgment. You can read the judgment as Messrs. D.N. Singh versus the Commission of Income Tax in Civil Appeal number 3738 by 2023, decided by two judges bench, Honorable Justice K.M. Joseph and Rishikesh Roy. The case revolves around Section 69A of the Income Tax Act. Section 69A of the Income Tax, in brief, says regarding how to deal with the unexplained money, unexplained valuable articles in possession of any person. When it is not recorded in the books of accounts, he is in possession of certain property. But on record, it is not brought. Then how to assess the income tax on that person? So he is not the owner. The owner should be held accountable, not this person. Second, as regards the interpretation, you have to understand that Section 69A deals with the properties like money, second, jewelry, and third one, bullion, or other valuable goods. Here, the taxing is on bitumen. Bitumen means almost tar. So, bitumen cannot be called as a valuable security. That's why I told you, in the case of Egyptian generis, suppose money, jewelry, and so-called bullion, or the so-called bitcoin, or the so-called platinum, or diamonds, they come in the same category. In that category, the so-called bitumen cannot come. Bitumen cannot come. Right? So, Egyptian generis is also discussed in this particular case. So, better read the judgment. Now, coming to the facts of the case, the appellant, that is Messrs. Dinesh, they are the contractors or freight contractors or load carriage contractors, stage carriers for carrying the bitumen or the tar from Haldia in Kolkata, and they will be transporting the same to different places where the roads are being laid in Bihar state. Right? So they used to carry the bitumen, but there was a scam. This happened in the year 1995-1996. The assessment year is 1996-1997. The scam came out. So what happened is, actually, the Messrs. Dinesh and company, they literally lifted, we can say, they lifted 14,507.81 metric tons of bitumen. They lifted from Haldia port, but they delivered only 10,064. That means almost 4,443 metric tons of bitumen is missing. They are not. It is found. This is a scam. So they have in the en route they have given it to some others, and something the scam has done. But anyway, since he has lifted, then he was asked to pay. Messrs. Dinesh, they were asked to pay 1,04,71,720 as additional tax to be paid. But are they the owners? No, they are only the carriers. Who is the owner? IOCL, HPCL, BPCL, they are the owners. So, if at all you want to collect the tax, you have to collect from them, not from this man. Then what happened to 4,443 metric tons of the bitumen which was missing in the middle? So, it is for the police to find out as to which is gone. Then that man will be held liable under cheating or misappropriation, whatever sections of law. But here, since this man lifted 145.07 tons of bitumen, you cannot ask him the delivery has made, the transaction was made for so many 1064 tons. For that only he is accountable. Regarding that, it is only criminal offence, not to be taken. So here the Supreme Court clearly stated that a thief cannot say to be the owner of the stolen property under section 69A. So Supreme Court said the appellant cannot be regarded as the owner of the bitumen because it is not found in his possession. Number 2, it is the property relating to HPCL, BPCL or IOCL, not his. So how can you add tax to him? So the appeal is allowed. Very good case law. So for understanding the same, already I told you, strict construction of statute, taxing statutes in interpretation. So better view my video once or twice, or better read the judgment and enrich your legal knowledge. With this, I am concluding. Thank you very much.